On the storm.
Gary, you gotta talk into the actual microphone.
Oh, wait a minute. This is what happens when I get here late. Okay.
Is that better? Can everybody hear him?
Can everybody hear me now?
Yeah.
Because it's Sunday, and welcome to our version of Riders on the Storm. At least those of us who stayed in Florida. Those people who are in Maryland, well, you got it a little bit later, maybe. Did you get any bit of that storm at all? Lucky son of a gun. Anyways, welcome back. We had a bit of an apocalypse ourselves last Friday. We had a guest that was sick, and we had a storm coming big enough to go ahead and wipe out half of Big Bend over here. So we are glad to be back, and we are glad to be back into the rotation.
I'm not ready.
Okay, start again. We're back, and we're. This is why we are semi-professional, guys. we don't want to give it away that it's that easy to do, so we're going to make it look really difficult by screwing up as little as possible.
That wasn't a screw up. I meant to do that.
That is absolutely fantastic. Yeah, you got your beard trimmed a little bit. I can actually see your collar again. That's cool.
You like that?
And let's introduce ourselves first off. We are your masters of cannabis. I am Gary Stein, your political director of Suncoast Normal and the master of public health. To my right, your left, is our deputy director and master of business administration, Carlos Angel Armida, the semi-Cuban portion of Ybor City.
I'm all Cuban, baby.
We'll have a long conversation in Cuban later on.
No speaky Spanglish.
And to your upper right, we have our executive director coming to us from beautiful Anne Arundel County over in Maryland, where they hit you above the belt line and below the belt line. And Chris, we're glad to see you're back too, because you weren't feeling that great the other day too. And you also had a family issue that unfortunately came across. So we're glad to have you back on the show. And Chris, go ahead and why don't you introduce your special guest today?
Well, before I introduce our guest, I just want to say that, we here in Florida, when we passed Amendment 2, there were a lot of issues that Suncoast Normal foresaw that was going to happen because the will of the voters oftentimes is not understood by the people in power who actually implement the will of the voters. And so the Florida legislature over the past several years essentially has had to continuously try to improve shortcomings in the medical marijuana system. And there are still shortcomings that happen every single day when it comes to it. We're still fighting for a legislative agenda that's going to improve the system and make it more patient-centric and protect people's civil rights. Medical marijuana is now a state-sanctioned medicine, and yet people continuously have their civil rights trampled upon when it comes to utilizing this type of therapy. And in particular, the court system is one area where this has happened consistently ever since its passage. And our guest today, Haydee Oropesa, is an attorney out of the Bay Area. And Haydee, you have a podcast called Florida You Judge, where you talk about many of these various issues. And most recently, there was a bench memo coming out of the Suncoast, pointing to addressing these issues when it comes to the judiciary and medical marijuana. And I was hoping that you could talk a little bit more about that.
And good morning, Haydee Oropesa, and thanks for inviting me, guys. So as you know, recently the Tampa Bay Times covered an article in reaction to a circuit judge, Bill Burgess here in Pinellas County, who wrote a bench memo. I shared that with you, Chris, where he addressed a situation that's happening here, particularly in the county courts, where for some time now, I'd say about a year, there have been some judges, not all, where someone's about to be sentenced to probation. And as part of the probation terms, when they impose the conditions, they say that you cannot use cannabis. Even if you have a medical marijuana card, you can't try to obtain a medical marijuana card while you're on probation. And so that has caused this controversy now. Some attorneys, such as myself, I'm waiting for the appropriate case to come through, where I believe that when I review the facts surrounding the particular case, if I after my review, I think that that's not a special condition that legally can be imposed. I'd like to try to appeal.
And by the way, can you hear me? Okay, is my microphone down? Is it not?
It's coming through.
Everybody can hear me? Okay, I couldn't hear myself. Anyways, Haydee, I just want you to know that I do geek out on your podcast every once in a while. I'm one of these guys that actually gets into the law, because when I hear things like, oh, the Florida attorney tried to sue the government to use the 14th Amendment to keep Trump from being on the ballot, and then they come back and they say, well, you don't have any standing. I say, oh, I get it. I found out why they screwed up. And so with the law, it always seems to be somebody has to screw up first, and somebody has to come back and fix it in order for them to recognize a problem and actually get to it. They don't seem to get to it in a standard linear way where there's a problem that is suddenly fixed. Somebody has to screw it up more first. And that seems to me that we had the situation here. And Burgess was fixing Viccaro's previous memo of, 6 months ago?
Right. So that case came out because Judge Vaccaro, she had a female whose name we should not share, but well, to protect people's for obvious reasons. Well, but so this is a case where she was being sentenced to DUI, and so from my understanding, it was alcohol based, the DUI, so there was no involvement with cannabis. And so when she goes before the judge to be sentenced, Judge Vaccaro tells her, you can, why do you have a card? And she says it's because of anxiety. She said, well, there's another way to resolve that. You can get a script for Xanax. So, right, that made headlines. The Drudge Report reported on that. Various national outlets reported on it. It was there was I think the majority of the public reacted strongly in opposition of that. Okay. So that would be a classic case for me to review, to see about appealing, or at the moment of sentencing I would have possibly objected. And I think now attorneys are becoming more privy to what's going on and trying to strategize and to see how to respond to this. But yeah, that's a special condition that was placed on her that perhaps should not have.
Yeah, and
legally, because as listen, the 9-page memo that Circuit Judge Bill Burgess wrote is really, really good. I shared it with Chris. I'm happy to share it with the public. Whoever wants to email me, I'm happy to share that memo. But if you have a medical marijuana card, or you want to have a medical marijuana card because you have a qualifying condition under the Florida statute, and you go to get sentenced for any offense, and that is pronounced, or they're about to pronounce that as a special condition, and you don't want to stop using cannabis because you do have a qualifying condition and it's helping you medicinally, then you should maybe put the brakes at that moment and ask for a reset to look at what to have somebody review that legally, to see if you can lodge a proper objection and follow up with an appeal if need be. But that's what happened. And it started off in Judge Vaccaro's courtroom. Some judges are kind of practicing this pattern of when, upon sentencing you and imposing probation, they are making that like a standard condition, instead of possibly, I can't speak for every case where it's happening, but that is happening here in Pinellas in the county court county courts. the defendant needs to assess whether that a condition imposed is one that can be legally justified.
And can that also be done during pretrial interventions as well, to impose a sentence where a person goes immediately into probation but cannot use the medicine they're currently using to take care of a condition they actually have that are actually being treated by?
That's a good question. And as far as the state attorney's office is concerned, that is a program that they're able to extend to a defendant. And so they're the ones that fashion what the terms are. I have not seen a problem here with PTI and them including that as a condition. In fact, I can't say this 100%, but I have it on good word that the state attorney's office, Bruce Bartlett, I don't think Bruce Bartlett's office is making an issue of throwing that as, requesting that to be a part of a probationary term when they're trying to resolve cases. I have not heard that. What the current practice here, again, and I'll reiterate, is some judges, not all, are, when you are sentenced to probation, they are, as a standard sentence, they are saying you cannot use marijuana while on probation, even if you have a card, and you cannot try to obtain a card. Okay? They're not addressing what the bench memo that Circuit Judge Bill Burgess wrote. It addresses that there has to be a special nexus. There has to be a reasonably related something reasonably related to a judge saying, no, you can't use it even if you have a card, or that would be a special condition necessary for the offender's rehabilitation, or for the offender, or because it's causally, or there's a nexus between the offense and them doing a special condition saying you can't use it because there's a nexus between what you're charged with, what you're pleading to, and your usage of marijuana, even with a medical marijuana card. There has to be some nexus.
Well, yeah, it seems to me the way he put it, he lays it out like a 3-step process.
Right.
First, the validity of the medical marijuana card has to be determined. Next, the court should determine, and this is kind of what you're touching on, if the drug had a substantial relationship to the crime for which the defendant is being sentenced. And then finally, the court should consider if restricting the drug is consistent with public policy, and if the public would be protected by the defendant not being allowed to use the drug.
Right. I'm going to read it, if you allow me, real quickly. The bench memo.
Man, I'm sorry. I just really confused. All right. So
It's okay. That's his normal state of mind, so don't worry about it.
and I didn't even mean to make the camera do that, but all right, if you want to, camera.
That was pretty cool.
So I'm really confused. Okay, first off, I can understand how a judge would have the ability to sentence you to probation, but how do they have the ability to decide how your probation goes, especially when it's something that you have a constitutional right? Floridians, correct me if I'm wrong here, guys, but Floridians have the constitutional right. It's in the Florida Constitution that we have a right to marijuana as medicine. Is committing a crime enough to take that right away?
So I'm gonna read. I'm not gonna try to paraphrase, but because again, this is a really well written, researched memo. But he addresses that on page 4. Judge Bill Burgess, section 381.986 does not, in any event, create a fundamental right to medical marijuana treatment. The right to use medical marijuana recommended by a physician is statutory in nature and is not so deeply rooted in American history and tradition and implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if the right was sacrificed, and thus a condition of supervision that the defendant not use or possess medical marijuana where the court has made appropriate findings does not infringe upon a fundamental right under the due process clauses in the constitutions of the United States. So for an example, do we have a fundamental right to consume alcohol? Okay, so because if you are charged with a DUI, right, and you go before a court, what is one of the things they're going to tell you? While you're on probation, you can't consume alcohol.
Yeah, you got to be sober.
So same thing with marijuana. You have a statutory ability to govern by the statute. If you have a qualifying condition, if there's a recommendation made by a qualifying physician, you can use it. But if that usage is going to, as Chris just mentioned, the three steps that the Judge Burgess sets out here says, I'm going to read them. Addressing the issue of limiting medical marijuana use by a probationer or community controllee requires a three-step inquiry. First, the court should examine the validity of any medical marijuana authorization claimed by the defendant. Okay, do you have a medical marijuana card? Yes. Second, the court should determine if marijuana use has a substantial relationship to the crime for which the defendant is being sentenced. So
if you get sentenced for possession, then what at that point? Then it goes to the third step, which is
well,
are you a danger to the public?
Right. Third, the court should balance the relevant considerations and determine if the proposed restriction is fitting and appropriate to the end that justice may be done, that any restriction imposed would be consistent with public policy, and that the public interest of society would be protected by limiting the defendant's medical marijuana use. I mean, he also gives prohibition of the use or possession of cannabis, including marijuana, for medical use can be a valid condition of supervision where, for example, he gives examples. The defendant is on probation for cultivation of marijuana, and after entering a negotiated plea, but before sentencing, the defendant obtained a physician's recommendation for the medical use of marijuana that is facially in compliance with section 381.986. The defendant is placed on probation after being convicted of cultivating marijuana, possessing marijuana for sale, and transporting marijuana. The defendant has abused his or her medical approval by diversion for personal marijuana use or possession for sale. There are concerns for public safety. So
am I overanalyzing this?
No. So basically,
this is just saying that if you get caught smuggling or growing weed, you can't smoke weed while you're on probation for that. Is that it?
So those are some examples. No, when a judge places a special condition, they're going to have to justify it. They're going to have to justify and say, you shouldn't do this because it's a public safety. Mm-hmm. You're addicted. And there's a safety issue to the public, because there has to be a nexus why you shouldn't be doing it, even if you have a medical card. I was about to say credit card.
Well, it's interesting how they discuss the nexus, and yet we are constantly seeing, and this happened to us last year when we were fighting the hemp laws, but we were told by a legislature to stay in our lane because of the fact that we were trying to talk about cannabis as and excuse me, and the retail basis and things of that sort, and how it was innocuous. And yet they're saying, look, we're the legislators, stay in our lane. Yet legislators are constantly taking medicine up as a hobby, essentially, and inserting themselves in between the doctor and the patient relationship and saying whether or not it is a valid situation. And they've given this oversight to the Department of Medicine, who does the reviews of these recommendations to make certain that they're all valid. So in regards to the first point, these things are overseen by the DOM. And if the DOM has not given this person any kind of restrictions, therefore the doctor has written a valid medicine, as far as we can tell. Now,
well, so are you talking about the Medical Marijuana Act here in Florida?
Yeah, the Medical Act here.
Yeah, they make a recommendation.
Yeah, exactly, a recommendation. Right? You don't use the word prescription.
Right.
But
it's not a prescription. I want people to understand that, because I think a lot of people, lay people, people who aren't into the law, people who aren't into politics, just don't understand the difference between what a doctor's recommendation is and what a prescription is. The doctor's recommendation model was adopted because of the Schedule I status, right? A doctor cannot prescribe a Schedule I controlled substance. It's not possible. It's not a valid prescription. Even if it was a Schedule II narcotic, right? Doctors are through the whole OxyContin crisis have been scrutinized over how they dish out Schedule 2 and Schedule 3 narcotics. Now, I do want to say that, Gary, you brought up a great point about the legislature always want to insert themselves into this patient-doctor relationship. Well, it's time the legislature in Florida insert themselves into the court system between the patient and the judge, because the state of Maine this past session adopted both in the House and Senate legislation LD 1311, which provides legal protections for adults who either possess or consume cannabis while on probation or parole. The legislation prohibits an individual's legal cultivation, possession, or use of cannabis or testing positive for cannabis from being a violation of probation, parole, or release pending trial unless the court finds that the cultivation, possession, or use of cannabis by the individual creates a risk of danger to the individual or others. And this bill is just now awaiting signature from Democratic Governor Janet Mills. But the fact that the Republicans and Democrats could come together in both chambers and get this done gives me hope. Now, the sad part is that Maine, turning out to be a more reasonable place than Florida politically, is probably where we're at when it comes to actually getting some progress on this.
And Florida still has issues where if you are a parent of a child, has a child in the house, if you have a medical card and you're using this cannabis for medical use, for medical reasons, and the Department of Children and Family Services comes into your home for whatever reason, they could make a connection, whether it's there or not, whether that there's a nexus between your use of cannabis and their reason for coming into the house. And that isn't always valid. In fact, it's rarely valid. And yet parents seem to have no protections when it comes to that situation, where if they have a medical card and they have a child in the house, they shouldn't be allowed to use their own medicine. That doesn't make any sense. Now, I testified in 2017 in regards to public use and in regards to whether or not, if a person's having a medical emergency, they should be able to use their medicine in that moment, even if it is in a public place. Mm-hmm. And basically, I was shot down. I would say, what happens if you are a veteran with severe PTSD, or a woman who was sexually assaulted and suddenly has a severe bout of PTSD while on a public bus? Can she pull out a vape pen and be able to medicate herself at that point in time so that she is okay while she's still on that bus and not affect herself or others because of her PTSD?
Well, we have a no vaping policy on buses, elevators throughout the state. So, does the public, the protection of the public supersede her individual rights? And the answer is yes. It's sad, but it's true. Our clean air laws supersede your own rights to medication in a lot of ways.
What about the whole thing about not being able to use cannabis while you're going through rehab, right? How did that go down? Like, do you guys
that passed?
Yeah, well, like that passed in some sort of medical bill or something like that. Like they tacked it on there like last minute. Is that what happened?
DeSantis signed it. It was part of a whole rehab funding bill type of thing.
It was, and they basically said that you cannot use cannabis while in a rehab facility.
And if your rehab facility allows you to do it, DeSantis can strip your funding.
I wonder what happens if they do that to methadone.
Well, Gary, what this issue and this bench memo really says to me is we have one more bill that we need to model after Maine that we need to add to our legislative agenda, because this is something that the legislature loves to preempt local government. They love to preempt the court system. Well, then let's go ahead and let's preempt away. Let's make sure that judges who think that you should be sentenced to using Xanax for the extension of your parole or probation should not be forcing people to do that. That you should have this option, that your medical marijuana status should not be used against you in parole, probation, or pretrial intervention.
It comes down to the same kind of stigma we're constantly dealing with. I love that commercial on TV where the guy's in a hard using opioids for a back condition, and he's saying his worst problem is the possibility of having constipation. If you're on a work site where you need a hard hat, and you're possibly in a
I don't know, man.
Yeah.
Constipation is
a
problem. Have you ever been constipated before?
I've been told I've been stuck up, but that's not
Well, the legislature has continuously failed to address the overreach of our bureaucracy. Right, Gary, you just pointed out about how unelected bureaucrats and CPS can come into your home and upend everything because you're a medical marijuana patient. Well, the Department of Health, which is led by Florida's Attorney General, who also is a COVID denier and a anti-vaxxer in a lot of ways, has lost a recent court case against Leafly. Leafly filed a legal challenge against Florida regulators who claim that online marijuana e-commerce violates a state law banning third-party cannabis dispensing services. And so the Florida Department of Health, basically used an administrative law judge's rule, and this Leafly does not prepare, they don't possess, they don't purchase, they don't transmit, they don't distribute, they don't sell or dispense medical marijuana in Florida or anywhere else. What Leafly does is it allows members of the public to go on their app and essentially look at what a dispensary menu is, and then they can essentially place orders and pick them up through the app. And so they've lost this legal challenge. And the crazy part is that this law that they put in place in 2021 that the Department of Health has been using would fine Florida medical marijuana operators $5,000 per violation. So the MMTCs just pretty much dropped Leafly in the state of Florida. And so this is, Leafly has had some layoffs. They had to reduce their workforce. But in 2022, they posted, $47.4 million in revenue and a profit of more than $5 million. So, this is Florida, want to be one of the largest medical marijuana markets, is really, now that they have this open available to them, I'm glad that folks are stepping up, and this, the sad part is that we don't have the money to leverage these big lawsuits against the state. The MMTCs themselves, in a lot of cases, pick and choose what they want to sue for and how they want to navigate the public. For example, if you go online and you look at campaign disclosures and donation disclosures, you can find some of the largest multi-state operators here in Florida are donating money to the Republican Party of Florida's Senate campaign fund, chaired by Colleen Burton. And I just wonders to me if the fact that Trulieve donated $75,000 to this fund is directly connected to Burton going after Carlos and other business owners like himself, because they're competitors taken away from their bottom line.
And that's today's big duh.
I'm just asking questions. I'm not accusing a pay-for-play scheme at all. But we know how Florida politics operates. The fact that businesses can donate in a state race in Florida, but in the federal government, that's totally illegal. The businesses do not give money to individual campaigns and such. But Trulieve dumping all this money into the PAC that's chaired by the senators that directly want to put Carlos out of business. Well, I'm just saying.
There's also, it doesn't stop there, right? Right. There a lot of ties can be found between Trulieve and Wilton Simpson, who runs the Florida Department of Agriculture. And it was definitely made clear that those hemp bills were pushed onto the senator and the representative from the Department of Agriculture. So Operation Candy Crush, all these press conferences that they're doing to show that people like me are drug dealers that sell to kids or whatever they're trying to make me seem like. It's ridiculous. It's ridiculous. There is clear ties between Trulieve and most MSOs and these people trying to do this. There's a reason why they nickname it the Stay in Their Lane bill, because that's exactly what they're worried about. They want people to stay out of medical marijuana. They're worried that we're giving a healthy alternative.
And let's be clear. We started this program in Florida, and still is supposedly as a medical program, and yet it constantly operates as a quasi-adult use program. I could say recreational, but that would be going one step too far for me. But basically what we're trying to say is that yes, it's a medical program. And yes, in order to step in and actually make a purchase, you have to have a legal standing recommendation from a doctor that has given you permission to go ahead and buy that. And yet, you look at the advertisements these companies put out for their products, and they say, you can get high this weekend by getting our great product. And when they go in there, they don't teach you, they don't say, yes, this is the exact right cultivar for your PTSD or for your migraines or for your pain. They say this has got the highest THC in the store. This will really get you buzzed. That is not a medical program. And as long as they keep that up, that gives legislators and litigators a chance to go ahead and constantly put these things where they treat it like an adult use or recreational program as well, and don't make it the medicine as the important thing here.
Well, Gary, I was reading most recently that the last non-MSO in Florida is actually going to be sold out to a new multi-state operator.
Yeah,
so
that's right.
Vitacan is going to be bought by Planet 13 out of Nevada. So Florida essentially no longer has a homegrown medical marijuana system. It has multi-state companies that are essentially operating here and putting profits before patients in a lot of ways.
And let's just for a little brief story here. We know that Harvest, once it failed as San Velasco, it started as San Velasco Nurseries. It was bought up by Harvest. Harvest was doing well, but Trulieve decided to go ahead and buy them. But you can't have two licenses in the same state. So what they did was they swallowed up Harvest, made it part of their business, and they spit out the license, just a plain piece of paper, which was bought up by Planet 13 for $55 million. And Planet 13, who has not cultivated a single thing since they got that license 2 years ago, had to abide by an amendment that we, as Suncoast Normal, helped put into the legislature, which says if you don't produce product within 2 years after you get your license, you lose that license. So in order to maintain their license, they bought Vitacan so they can absorb that and then spit out that license again. So once again, we got a situation of swallowing and then spitting out a license and letting it go to the market for whatever price it goes at.
This is why we lost our audience for everyone rating on YouTube, Gary. But I love you.
Haydee, I want to apologize for Gary's sign.
No, he's delightful.
He does not know how to speak to a lady.
Yeah,
If there was something off color there, I completely went over my head. Okay.
Well, Haydee, just you're an attorney, so commentary isn't something that you usually do. You provide legal advice, you interpret laws and such. But what's your 2 cents on all this? How do you feel about where we are now? Essentially 5 years, with 6 years later, with everything here in Florida in the medical marijuana system.
Well, I mean, I didn't see a problem until why I'm here talking to you all today. I mean, another thing I wanted to mention, the irony is incredible that there's no inquiry made of defendants when they're put on probation as to their prescription with much more harmful drugs. That's not an issue. Like the verbiage when they're doing the sentencing is, you can't take anything unless it's lawfully prescribed. Right? There's the nuance of whether it's prescribed or
recommended.
That's correct. So if it's legally prescribed by the big pharma doctors for big pharma, then it's okay. Like, and for the story that made a headline some months ago with Xanax, we know is bad. That's a highly addictive drug that is incredibly harmful. Yet, with our medical marijuana program here in the state that was passed by the people legally, amended the Constitution, there's some judges that are suggesting maybe look into getting a script for a more harmful drug versus a plant. Now, here's the other thing that some judges are doing when the issue of a medical marijuana card is brought up. They're starting to do an inquiry wanting to see I cringed somewhat recently, a judge making in open court inquiry about a person's medical diagnosis. Why do you need the card in open court? I mean, there's privacy laws. So, um, you know, there are also some judges are also saying, making inquiry about why do you need it, and then they need proof. They have go through this whole rigmarole of, I need to see the records, who recommended it, the qualifying physician. So
Wow.
Judge Burgess in the memo on page 6 um, says a court also cannot require a defendant to prove medical necessity in order to obtain and use marijuana for medical purposes under section 381.986. This, myself and some of my colleagues are of the position that once you say I have a medical marijuana card, that should be it. The inquiry should end.
Yeah, as long as the card is valid from the state.
That's
there
correct.
There should. It's like having a driver's license, and they're calling into question whether or not you passed the driver test, adequately.
And some of us take the position that you're, as a judge, you're maybe quasi acting like a doctor, because now you're trying to oversee and make sure that the card is valid, and then now you're making inquiry on why do you need it and which doctor recommended it, which doctor there's two doctors. Like some of us say it doesn't matter if it's the recommending and the physician that that one of them makes the recommendation and then the other one does the qualifying of the condition, right? Sometimes but it could be one and the same. But it's here, some of the judges are saying they want to see who the qualifying condition doctor is, and then the one that made the recommendation, both.
Yeah.
So
if your primary physician validates your qualifying condition, but they're not certified to recommend it, they tell you, here, go get a recommendation.
That's right.
Now the judge is calling into question your validity because your primary physician isn't the one that recommended it.
That's correct.
Well, he just maybe didn't have 8 hours to take the test. Maybe he didn't want to do it. Maybe he doesn't want to go through the bureaucracy of doing it. There are a number of reasons why a doctor may not be certified to recommend medical cannabis, but the fact that they are certified to recommend medical cannabis no less invalidates them as a physician.
And not only that, but the one that makes the recommendation could also be the one that diagnosed the qualifying condition. Right. And sometimes they make it like it has to be two. Like, we don't want to hear from the one that recommended. We want to hear from the one that actually made the or said yes, certified the qualifying condition.
So as a defendant in the court system, I basically am going to have to call up my doctors as witnesses because of these judges.
And what you're doing,
yes, that is correct. That is correct.
That's ludicrous.
And you are asking your doctor to break HIPAA regulations, because you can give up your own protected information if you like. You're allowed to do that, but a doctor is restricted by HIPAA from giving.
Someone listen. So that's to me, when I see that, that makes me cringe. Yeah, and that's happening. That's happening where.
I mean, what are they going to start subpoenaing? The drivers at the test instructors at the DMV to validate if your driver's license is valid.
Well, but
it's the same thing,
And here's the thing. Yeah, so some of us look at this as, wow, it's almost like the MD that does the recommendation. It's like they're treating them like they're like
drug dealers.
Or somebody made an analogy like with public defenders, like they're not real lawyers, which they are. They're real lawyers, and sometimes people kind of like degrade them to an extent by perception that you're not really a lawyer. It's the same with the MD. It's an MD. They're making a recommendation. They're a doctor, but for some judges, that's not sufficient. They need the actual doctor that certified the qualifying condition. So. But they're not doing that. They're not going through the same hoops with doctors who prescribe Xanax.
Yeah,
let's go and make inquiry into that, because some doctors now currently they're afraid of prescribing the drugs that really lead to deaths.
Gary brought up methadone.
Same inquiry.
Yeah, I'm sitting here thinking about how Florida contributed to the opioid epidemic, how we had all these pain management centers.
We had a pill mill loophole that was as large as
And doctors for the longest time did not give a shit about that.
No,
That-
it's part
Some
of
are now because
it's
they're
part
getting
of popular culture. Like if you ever
Yeah.
watch Claws on TNT, the premise is about a pill mill doc in Manatee County funneling money through the mafia down there, through the redneck mafia.
Yeah.
Yeah, but you know what? I just saw. I went to a doctor to accompany a family member, and in the exam room there was a paper saying that that doctor was no longer prescribing opioids.
Mm.
So,
nice to
so
know.
well, there some doctors are becoming afraid.
Well, I testified in front of the BOM a couple of years ago to ask them if they had any kind of database on how many people had been Baker acted for suicide by Xanax, who after their 72 hours of incarceration were given a brand new prescription of Xanax to go home with.
Mm.
And they didn't have that information.
Mm.
They really sweated it out, but they decided it wasn't worth looking into.
I don't get it, man. I want to leave Florida. The politics here fucking suck.
Well, Carlos, let's be
No,
clear
but wait,
about
wait.
something.
Just to be fair, not
go
all
ahead.
judges. Some judges, like Circuit Court Judge Bill Burgess, you know, when Justin Garcia, props to him, put out the recent article addressing Judge Burgess's memo. He said that in a rare move, and that is a rare move for a judge to actually issue a memo addressing this. Okay, when there's a current situation such as I've already mentioned and described within that very circuit, where some judges are doing the very things that that I'm talking about, going through hoops to try to get somebody to disclose their medical information, and I need something from your doctor, the qualifying one, and prohibiting usage for no other reason other than that they say you can't do this.
Now,
There's no reason. They're not justifying it. The memo addresses very nicely that look, legally they have to, if they're going to impose that, they have to have there has to be a special condition. There has to be a legal nexus. So for your viewers, those who are listening and who will listen, if you're in Florida and you happen to be in this jurisdiction, I don't know other jurisdictions where they're practicing that. I know that when they put out the article with Judge Vaccaro, they sought comment, Justin Garcia did, from Hillsborough. And Hillsborough, I think my recollection of their quote was, they don't play doctors here. Okay? So it's legal. If you have a card and you show your card, that should be it. If I were on the bench and somebody showed me a card, that'd be it for me. Unless there's facts that would, in my mind as a judge, I would need to maybe for a particular case say you can't, and here's why. I have to explain why.
Mm-hmm. Just like when they take your driver's license away, right? They got to explain why, right?
Sure. Like if there's a special condition on probation, because we're talking about probation, we're talking about you're being sentenced and you're being placed on probation. There's conditions, standard ones, and then if there's a special one like that, you can't drive. They take away your license. They suspend your license legally. But there are times that judges could say your license is suspended but there has to be a reason, a nexus legally, not just because you say no, you can't do it.
Now, before you get to the judges, you also have to have a prosecutor that brings it to them first. Do you see a difference in the zeitgeist or the Gesellschaft or the environment of the Hillsborough County since Andrew Warren left?
Do I see a difference?
In the way things are being brought to the judges right now, because obviously Andrew Warren was removed from his post because he was too woke, whatever woke definition you had at that time.
Well, we worked really hard to get him elected because we saw Mark Ober, his predecessor, as one of the worst prohibitionists in the country. I mean, he was putting more people in jail for cannabis than all the violent crimes put together. And I mean, there were kids being direct filed as young as 8 years old as adults under his tenure. So we pushed that. We also supported Monique Worrell and Aramis Ayala in Orange County, and we see Rick Scott and DeSantis remove both of them. So I think the question is, is the public better served by these appointees from the governors than the people they elected? And do
So
we see a
Gary,
difference?
is your question as it pertains to this issue? Is there a different
Well,
difference in those two administrations?
well, this issue and in general, because I found that your state attorney does really set the mood as to what cases go forward and which do not. What are the concentration and priorities of collections of different types of crimes and things of that sort?
You know what? I can't really speak to that. I have not noticed any difference. That's the truth. I mean,
Fair enough.
most of my colleagues, I think, would be of the same position. There's not a huge difference that's noticeable between those two administrations.
No, I think proactively. I look at, like, for instance, what's going on right now with Alabama and their abortion issues, where they believe that if you go across state lines to go ahead and get an abortion in a legal state, then that is actually a conspiracy to commit a crime in another state. And so therefore they're going to go after you under those bases. And I wonder if people are going to take that up as a precedent and start saying that if you go to a state that is legal for adult use cannabis and you bring and you buy something there, have you committed a crime if you've gone across the state with some friends to go ahead and pick up some adult use cannabis in another state?
Well, that's an issue that they're addressing in Kansas right now, Gary, because that, people go to Colorado all the time to get cannabis. And they drive right back across the state line there.
Yeah, what is wrong with Kansas?
Well, if you look at the country, Kansas is a dead zone, right? Because Missouri has it, Colorado has it, Ohio is getting ready to vote on adult use. You have medical in Indiana, you have full adult use in Illinois, you have full adult use in Maryland. I mean, you can drive across the Eastern Seaboard pretty much and be in a safe zone until you get to Kansas, and that's an 8-hour trip that you do not want to get pulled over.
Absolutely. But again, it has a lot to do with what the prosecutors are deciding that they want to go ahead and file or not file. And in a lot of cases, we have state attorneys who say it is not worth the court's time to spend all this time on trying to bring people to court for a simple possession.
Well, and let's ask this question. What case have we seen where somebody's been prosecuted in Hillsborough for having an illegal abortion?
Good point.
Well, I haven't heard of any.
No,
I know of.
No, I think Andrew Warren's mistake was writing pen to paper saying that
Right.
he wouldn't. Like he could have just been like, he could have just not. You're right, but this rises to the level of state attorneys are both agents of the court system and also politicians, and it's like you're all a politician that can be removed by the governor. So if you challenge him politically, like here we are today, we've had 2 state attorneys and under DeSantis, removed.
I know, but you know what? So some people's position on what you just said about him doing himself in for signing a letter, I agree with you. But some people said, well, he's supposed to do that because he's supposed to be publicly in support of the
He's
Democratic
he's a
Party's position. So right.
He's elected. He's an elected official. So like, unless we're going to, I mean, what if it was a public defender? Would they have been removed?
I mean, we have a lot of
Maybe.
legislators who do not pay attention to what the hell their constituents want. They ignore the polls and they go straight for what is politically advantageous for them at that time to move their jobs forward.
A public defender office is not as it's important for sure, but
It's not as politicized, right?
well, no, it's not. I don't think voters really care come election time so much about that office. The state attorney, on the other hand, they have the power to bring criminal charges. It's a more powerful office.
Well, when we first wanted to address the issue of civil citations for possession, the first thing we went to, Carlos and I went to our public defender, Julianne Holt. We said, "Hey, is this something that is plausible? Where are we going to hit these legal bumps at? And then just so happens,
Yeah, but her position is that I don't believe that she's in support of marijuana usage. I believe she's in support probably of people that have a card, but I mean, if I'm not mistaken, her and the current public defender here in Pinellas were asked about marijuana, and they both declined to speak on that issue.
I think in part because they don't think it's a priority.
Well, locking people up for cannabis, again, seems to be one of the most fruitless ways to protect the public, right? I mean, unless you're arresting a cartel boss who is running a plantation that is producing millions of plants and supplanting our legal system, I don't see the value in locking up everyday Americans for possessing, an ounce,
For real.
2 ounces,
And you know what? I could be wrong, but it'd be interesting if ever you have time and are interested. You can ask the public defender Sarah Molo in Pinellas and Hillsborough what their thoughts are about these issues.
Yeah,
if they talk to us.
Well, Haydee, here's an issue. We talked a lot about today about the issues of probation and parole and such and medical marijuana, but what about the issue of being precluded from a job or losing a professional license because you're a medical marijuana patient? Because that's still happening in Florida.
Well, yeah. So you know what? It's interesting because that was also addressed in Judge Bill Burgess's memo.
Oh, tell us more, please.
Yes, of course. I wanted to.
Carlos, you're our everyday guy in all of this. Gary's is public health, so he combs through the bureaucracy, the fine tune them. I'm a public administrator. I make sure the bureaucracy is doing right. But you're a business guy, so tell me, how are you feeling in all of this legal mumbo jumbo discussion?
I feel like in 2 years in Florida, if I want to use CBD and have an abortion, I'm gonna get arrested.
So you can call me. I'll give you a free consultation. Okay. But anyone that's listening, again, free consultation. This is important. I think, I'm happy to give a free consultation to someone that finds themselves in a situation dealing with their medical marijuana card. So this is what it says. The statute. Section 381.986 does not restrict the rights of an employer to enforce a drug-free workplace program and does not require an employer to accommodate the use of medical marijuana in the workplace, nor does it immunize defendants from probable cause searches based on the odor of marijuana. That's another issue, that there has to be a legal analysis when there's a search based on odor. So that's a reason to, seek out a competent attorney to analyze your specific facts to see if there's a violation of the fourth or any of these other issues that we're talking about. I don't see how, in what context, employment wise, fired because the employer finds out that you have a medical marijuana card.
We've seen this happen in multiple public employees. We've had a firefighter lose his job because of it. We've had school administrators who got injured breaking up a fight between teenagers.
I read that. I remember that.
Utilizing pain management. Teachers who use it for anxiety. And then on top of it, you're not just losing your job. Some of these people are professionals, like a school counselor can have their counseling license revoked.
Or corrections officers. How about that one?
And not to mention, the state of Florida. Yeah, I mean, I was thinking of firing Gary from Normal because he's ugly.
And I like salami in my.
That's fireable.
You could do it.
I gotta tell you, no, for real. You have salami in your Cuban sandwich, you gotta go. I'm gonna terminate.
Haydee, you are the best guest we've ever had. No, it's in the state of Florida. You can fire somebody for almost anything.
We're gonna have to get with a good employment lawyer. I can't advise on those issues, but I can make a recommendation of good employment lawyers.
Well, Haydee, to that point, should we continue to push that as part of our legislative agenda? Should we pass an employment protection bill in this state to say that you should not be precluded from a job or fired from a job because you're a medical marijuana patient, unless there's some public interest in protecting people from your patient status?
Yes, of course. I mean, people that are taking Xanax and more harmful prescribed drugs are not being treated the same.
So that goes back to, that also is the specifics of how we would draw up the legislative language, because a school bus driver can legally take Lunesta and Ambien at night, wake up in the morning and pop a Xanax, and then go drive your kids to school. But God forbid that the bus driver takes a toke of his medical marijuana when he gets off, but it's in his system, and then they test him randomly, and then all of a sudden he's being fired and losing his CDL,
Yeah, and I do have a bill that was supposed to be an amendment to our employee protection bill, which is basically a study of first responders to verify the fact that if a first responder uses cannabis when not on call and not on duty, and might still test positive while on the job, does it affect their performance? Because that should be the key. That should be the whole point of the whole situation. If a first responder has to be at their best when it comes to performance is concerned, is their performance affected if they use it when they're off duty and not on call?
There has to be
Right, for sure.
Well, I had a friend who was an EMT who was utilizing cannabis to keep their lupus, symptoms in check, and they had to give up being an EMT because of the whole, drug testing, losing their license, that sort of thing. It was like, well, I have to give up my dream and my career, and that's, I just like it's so ludicrous to me that we live in a society where that's the case.
Well, not too long ago, there was a former resource officer who was retired and was brought back into the fold after, I believe it was after Mary Stone and Douglas, as a resource officer, even though he had PTSD, and he was stationed over in Plant City. He had an episode, ended up going home and killing his kid and his grandkid and himself. And I sat down and I talked with Sheriff Chronister, and I said, what do you do for your officers, for your law enforcement officers who have these situations, who have PTSD? And they said, well, we have these acupuncture things, we have these yoga things, we have these meditation things. And I said, but in lieu of the accident that just happened, is that enough? And he said, no, but we're going to still strive to see what we can do. I'm not allowed. At this point in time, we are not allowed to even consider that. And I said, if there was a study that showed that it was considerable, would you consider it? He said, well, I have to see the study first.
Here's the problem, Gary, is that there are studies that come right out of Israel, but for some reason in America, we don't accept non-American studies as valid science. And that's the most asinine thing to me, because Israel actually allows folks in their armed forces who are on reserve duty or less, as long as you're not on active duty, you can utilize cannabis. And you got to think, some of these guys go into situations to where they may have to pull the trigger on a teenager or even a preteen in some of these battle zones that they're in. And it's ludicrous to me. And I don't want to get into Middle Eastern politics and such, but the fact is that there are studies coming out of countries that effectively utilize this for first responders. They utilize it in hospitals. They utilize it in their military. But for some reason in America, we invalidate all that science because it's not coming from the Food and Drug Administration, which I can tell you as a public administrator is one of the most corrupt agencies in all of American bureaucracy.
I can't stand the Food and Drug Administration.
I mean, we've had situations in history where it's gone the other way. I mean, it's well known that the Nazi armies were totally hyped up on amphetamines. That was how they made themselves into an absolutely killer machine, so to speak.
How do you march across Europe in a week? Oh, amphetamines and cocaine, clearly. They put it in the chocolate bars.
But on the other hand, if you have a drug that makes your soldiers more thoughtful in the way that they're working, and those even with hypervigilance, you have to make a decision in a split second. You have to be in your right mind kind of situation.
Yeah,
but
meth makes you a Nazi.
If there's a medication that gives you clarity,
and weed makes you woke.
Well, I don't know about
that. Can I real quickly insert a footnote, because I did make reference to something and I want to with actual source. So the Tampa Bay Times headline of pot pardons, Tampa Bay law enforcement officials weigh in. They had a bunch of Susie Lopez, I think, Gulteri weighed in. And so it says the Times asked local leaders about President Joe Biden's call for state level pardons for marijuana possession and reclassifying the drug. So we had Clearwater Police Chief weigh in, Gulteri, Bruce Bartlett declined to comment. Tampa Police Department's Public Information Office did not respond to questions submitted for former police chief now. Mary O'Connor, but O'Connor's boss, Jane Casher, who previously served as the city's police chief, praised the move and said she supports statewide pardons. Now, Chief Holloway also responded. Chad Chronister helped develop the county civil citation program for people in possession of less than 20 grams. So when Public Defender Sarah Molo and Julian Holt were asked, they were sought out for a reaction, they did not respond to a phone message. So they're silent on that. And so I just wanted to be able to provide the source from which my recollection when you mentioned that office. And one other thing, I don't know when you guys are done with your podcast, but I wanted, before coming off here, earlier when I made reference, or when we discussed the story of Vaccaro and the young woman who was suggested that maybe to try Xanax, and what I would have done at that moment, I don't want to second guess whatever it is that attorney did. I don't know the reasons why they did or didn't do. I know that at that time, I may not have acted legally or reacted in the way that I would now, because we have more information now. This has been something that's been coming along for about a year. But at that precise moment, I may have just said, okay, this is, talk to the client. This is the way it is. What do you want to do? But now, because we've become, myself and some of my local colleagues, I can tell you that they're very as passionate as I, and are also waiting for the right case also to challenge. But I don't want to, in any fashion, be critical of what that attorney did, because I may have done the same thing. But now, since we have more information and we've looked at it and researched it, and even thankfully the circuit court judge went ahead and wrote this incredibly edifying memo to help us sort through these issues and respond to them in a legal manner to protect people who carry a medical marijuana card. I just wanted to mention that, so that it doesn't seem like I was being critical. That I referenced that as what I would do today if I have a perfect case where a judge is sentencing my client and throws out, you can't do this unless there's a special nexus condition that they can lawfully, that my position would be that they can lawfully impose. I'm going to, with, of course, in agreement with the client, because the client has to be the one that says, yes, we're going to challenge this. I would seek to challenge it.
And I greatly appreciate you bringing this to our attention, because I'm going to take this memo and I'm going to go through it with a fine-tooth comb and pull as many references as I can out of it for our bills and resubmit them before we're filing. So we will have more solid judicial references in regards to why you should not be fired for having a cannabis card, why you should not be kicked out of a nursing home or a hospital, having your medicine taken away or taken off the transplant list for having cannabis, and why. Wow. And all the other, and of course the patient, the Parent Rights Protection Act, which we're working on right now, which talks about the nexus when there is no nexus of a parent's use and a child's endangerment. So we appreciate you bringing all this to our attention, and we're gonna fold that in and get back to you to make sure that we don't screw it up when we go ahead and start testifying in front of the legislature.
For sure,
bills to bear.
Yeah. Well, Gary, on that note, I think it's time for the news.
Absolutely.
So the biggest news this week, I think everybody can see, is that there was a leaked Health and Human Services letter that calls upon the DEA to reschedule cannabis. Bloomberg News obtained a letter from a top Department of Health and Human Services official recommending that the U.S. Drug Enforcement Administration reclassify cannabis from Schedule 1 to Schedule 3 controlled substance under federal law. The letter dated August 29th comes 10 months after the Biden administration requested the Secretary of Health and Human Services and the Attorney General initiate the administrative process to review expeditiously how marijuana is scheduled under federal law. While he was campaigning for the presidency, Biden repeatedly promised that he would seek to reschedule marijuana. And here we are, almost 4 years into his first term, and seeing, with re-election coming up next year, he's going to be hard pressed to deliver on this. Now, the Department of Health and Human Services recommendation now goes to the DEA, which will conduct its own scientific review. In the past, the DEA has employed its own 5-factor test, which differs from the Health and Human Services criteria to determine whether or not cannabis ought to be rescheduled. On 4 prior occasions, the agency has determined that cannabis failed to meet any of its 5 criteria. In 2016, for instance, the agency concluded, based on the established 5-part test for making such determinations, marijuana has no currently accepted medical use because the drug's chemistry is not known to and reproducible. And there are no adequate safety studies. There are no adequate and well-controlled studies proving efficacy. The drug is not accepted by qualified experts, and the scientific evidence is not widely available. If there ever was a load of horse shit out of a government agency, it is the Drug Enforcement Administration. Anybody can go on to PubMed.gov right now, type in cannabis, and find tens of thousands of studies. As a matter of fact, we're going to talk about some of those studies right now. Coming out of Basel, Switzerland, a study shows that the inhalation of CBD-rich cannabis doesn't negatively impact simulated driving performance. According to clinical trial data published in the International Journal of Legal Medicine, a team of Swiss researchers assessed that the impact of CBD-dominant with less than 1% THC cannabis on simulated driving abilities. So this goes to many of the products that Carlos sells in his shop, and they found that consistent with other studies assessing the influence of CBD on psychomotor skills, investigators acknowledged no significant differences regarding driving ability were found between CBD cannabis products and placebo. Shocker there. Looking more at a clinical trial coming out of San Francisco, California, the adjunctive use of CBD was effective in patients with focal dystonia. And so the adjunctive use of proprietary plant-derived CBD oral solution, Epidiolex, which we know is produced by Big Pharma, improves symptoms of adult onset blepharospasm, BPS, according to placebo-controlled trial data published in the Journal of Translational Vision Science and Technology. BPS is a form of focal dystonia associated with uncontrollable eyelid twitching, among other symptoms. And a team of investigators affiliated with the University of California in San Francisco assessed the adjunctive use of either Epidiolex or placebo over a 6-month period with 12 patients for the disorder. They found that a daily 200 milligram sublingual dose of CBD was found to be well tolerated without adverse events and provided statistically significant improvements in several BPS parameters.
And I would suggest to Mitch McConnell in his recovery from his concussion that a high CBD tincture would be well within the parameters of fixing your neurological difficulties.
Well, I'm glad that you brought that up, Gary, because coming out of Hamburg, Germany, a recent study which had data published in the Journal of Medical Cannabis and Cannabinoids, cannabis inhalation is associated with sustained improvements in pain and sleep with patients with chronic neuropathy. And German investigators assessed that the use of herbal cannabis in a cohort of 99 patients suffering from neuropathic pain. The participants in the study inhaled cannabis containing moderate levels of THC. That's 12 to 22% for 6 weeks. And within the 6 weeks on therapy, the median pain scores decreased significantly from 7.5 to 4.0 on a scale of 10. And the proportion of patients with severe pain, which were scoring greater than 6, decreased 96% to only 16% of the patients. Sleep disturbances were also significantly improved, with the median scores decreasing from 8 to 2. And these improvements were sustained over a period of up to 6 months. There were no severe adverse events reported. So again, when we hear the DEA say these things like the data isn't there, there's no medical reasons, it is beyond me to understand it. Because, again, coming out of Athens, Greece, A survey recently showed that cannabis treatment improves the quality of life of patients with neurological disorders. Are you hearing this, Mitch? Okay, go read the data published in the Journal of Advances in Experimental Medicine and Biology. Patients diagnosed with neurological disorders such as epilepsy, Parkinson's, and others experience improvements in their symptoms following medical cannabis treatment. A team of Greek scientists assessed cannabis use in a cohort of 100 patients, and the quality of life was assessed with the use of a 36-item health survey. Researchers reported that a majority of the patients who received medical cannabis to treat their neurological disorders, 58% reported a decrease in their symptoms, including better energy and vitality, and an improvement in sleeping and appetite after receiving medical cannabis. Participants who reported a longer period of receiving medical cannabis reported statistically significant more energy and vitality, but also better mental and general health status. So again,
Yeah, and I should tell folks again, if you're going to rely strictly on medical research that's done here in the United States, there's nothing wrong with that in essence, except for the fact that the DEA for the last 30 years has basically only concentrated on the harm of cannabis and had nothing to do with the actual benefit of effects. But now that they've dropped the single convention at the UN, there'll be a lot more international studies that you will see that will bring more to light in regards to the medicinal benefits and their concept of what is adequate as far as the DEA is concerned in regards to reports is going to become less and less of value.
well, before we go, and while we're still on the news, I do want to say that this idea of moving cannabis from Schedule 1 to Schedule 3 is not the solution. It is NORML's official position that rescheduling is not enough. It will be interesting to see how the DA responds to these recommendations. But as you said, Gary, given the agency's historic opposition to any potential change in cannabis categorization or federal law, for decades, the agency has continuously, pushed against the harms of it, while also providing medical cannabis to people like Irv Rosenfeld from the federal government. And this conflict just has to end. It's intellectually dishonest to categorize cannabis in the same placement as heroin. It is equally dishonest to treat cannabis in the same manner as anabolic steroids, which are Schedule 3. Majority of Americans believe cannabis ought to be legal and the hazards to its health are less significant than those associated with federally descheduled substances like alcohol and tobacco. And like those latter substances, we have long argued at NORML that the cannabis plant should be removed from the Controlled Substances Act altogether, thereby providing the state governments, rather than the federal government, the ability to regulate marijuana in the manner they see fit without violating federal law. And in some states, we hope that they'll regulate it as the agricultural commodity that it is. Others are probably going to more tightly regulate it as a nutraceutical or a healthcare product. But the fact is that people should not go to jail for it. People should not lose their jobs for it. People should not lose their kids for it. People should not be denied medical treatments for it. You should not be kicked off an organ transplant list because you utilize it. All the things that we talked about today. You should not have your probation violated or your parole violated or your issues with the court system. It should not affect you, because the fact is that utilizing a plant to live a healthier life that God put on this earth for us doesn't make any sense. It is a violation of both natural law. It is a violation of rights. And I think that is where the legal system has this thing. Right now, the way we've been able to move cannabis forward is that it is not an inalienable right, right? But the fact is that in a lot of ways, if we're going to treat cannabis like an agricultural commodity, we have to establish that people have a right to food. Ironically, when the United Nations took up that vote last month, only one country voted in saying that you do not have a right to food and clean water, and that it was the United States of America.
Bless our hearts.
We're the good guys.
Absolutely. And so the judicial system has weighed in, at least through Judge Burgess, and we greatly appreciate that. Now, that means that we have to lean on the legislature and the would-be legislature. And that means that because we are now heading into a primary season, we want to hear from the candidates as well as the elected officials on how they feel about these issues, so we know how to vote. Hopefully our vote does count. That's one of the only things we still have left, practically, because they seem to want to screw things up after we vote. But we would like to put the right people into office, people who actually want to listen to their constituents.
Yeah.
And
Maybe
we are your constituents.
what,
We are the majority of your constituents. Yes.
Yep.
when I fire up the broadcast again, because I've been on somewhat of a sabbatical, I'll have any of you three gentlemen on to give a status on where we're at with this issue, especially for any judge that's seeking re-election.
Well, I have been trying to get Congressman Mast on. He has a great bill for veterans right now, and he has some clue in regards to the DEA report, as well as
Yeah. And just for the record, Carlos
Blumenauer.
hardlined our internet down there at the shop. So Verizon, you still suck even when you hardline it. It's not Wi-Fi. And he has Spectrum running too in the shop. We have 2 internet service providers, and somehow we still wind up with high-speed delays. So Verizon and Spectrum, get your shit together, please.
Well, I blame wokeness. Just because of it. But
are we back? Is that
no, you're back. It's just I had to take the time to do that tirade while Gary was frozen because it irritates me to no end. We do everything possible to prevent delays in the podcast, and somehow Verizon still fracks it up.
What's interesting? We were hardwired into Spectrum, and now we're on the Spectrum Wi-Fi.
Now
that's working better than the hardwire.
Oh, jeez, Louise.
Miss Mariscal Powell, Congressman Mast, Congressman Blumenauer, all the other candidates coming up for these great offices. We want you on the show, and I'm just saying that if you don't come on the show when I call to ask you, I will be sending Mr. Crow's invoice to Clarence Thomas to your house so that you have to pay it.
That's too funny.
I'm just saying.
Gary, I'm glad you brought up about elections because there are 2 special elections in the Florida House that are coming up.
Yes.
And we've actually made some endorsements in these elections. November 7th is the primary election for Florida House District 35, which is in Osceola and Orange County. We've made an endorsement. Actually, one of our own members is running, Tom Keene, who's running for State House in that district as a Democrat, and we have endorsed him based on his views and policy positions. And down in the Miami area in South Florida, House District 118, which the general election, because there's no primary challengers in that, it's just going to be Democrat, Republican, and a non-party affiliate running in the general. And we'll be releasing our formal endorsement, but we are going to be endorsing Johnny G. Farias in House District 118 based on his positions of wanting to support medical cannabis and the adult use of cannabis in the state of Florida.
Now, we may be grassroots, and we may not have tens of thousands or hundreds of thousands of dollars in envelopes to push towards the candidate to elected officials.
Talking about bribes.
To get our work done. I am just saying.
It's called lobbying, according to Truly.
It's called lobbying, spelled with a dollar sign.
Bribe's a bribe, bruh.
Like Keisha, spelled with a dollar sign. I don't know where you put it in there, but it worked.
But Gary's right. We don't have a lot of money to push this, but what we do have is time. We have talent with an amazing board, and what we need is members like you. We need a membership that we can leverage. And again, your dues don't go into us having big paychecks or anything. Your dues don't even go into producing this show. Carlos donates a lot of money to help us produce this show. What your dues do go to is educating the public and pushing our legislative agenda. And so become a member today so that we can continue to reform the laws here in Florida and that we can continue to work with local and city and county governments to adopt decriminalization ordinances, that we can educate the bureaucracy, and that we can continue to fight in Congress at the federal level in ensuring that we can legalize cannabis, that the civil rights of cannabis users matter. And so we're asking each and every one of you out there, it's only $25 a year to make that leap. If you're someone whose membership has lapsed, no worries. We want to welcome you back. Come on back. We have an amazing legislative agenda lined up, and we're going to need volunteers and members all across the state to attend their legislative delegations over the next few months, to go up to Tallahassee during committee weeks, because the fact is that the work has to happen now. because if we wait till January, the checks have already been signed by the big money donors. The agendas have already been set in motion. We have to get it at the grassroots level. And so that's why we need your support. We need your time. We need your treasure. We need your talent here at Suncoast Normal as a member.
And our bills will be on suncoastnormal.org's website as soon as I finish getting my button gear and get it on there so you guys can go ahead and read it and know what you want to go after. So then you can take that piece of paper and take it to your legislative delegations, which are happening all over the state right now. even some of the more operative ones. We're not going to talk about Lake City because they're kind of crazy up there with Mr. Baxley. But we are going to let you go ahead and help this happen, because people want to hear from the constituents because they're not listening to the polls, so they might as well listen to you. And that said, by the way, maybe salami isn't the best choice, but I am pushing to have Cuban sandwiches with, get this, yellow curry paste instead of mustard.
Gary,
just think about it.
Gary,
yeah,
you're going to make me commit a hate crime across the cyberspace. You better stop that, okay? All right? I am a Tampa Cuban. I will subscribe to salami. I draw the line at curry mustard.
Well, I'm not making a kosher Cuban sandwich, so don't worry about that. That would be a script too far. Gotta have the point.
Oh my goodness! But Haydee, as we close out, why don't you tell folks just a little bit more about your show, yourself, where they can reach out to you if they have they want to get a legal consult or even possibly hire you as an attorney.
Why, thank you. So I do I have been hosting Florida You Judge for some time. I was on a bit of a sabbatical for some reasons, but I'm going to start doing broadcasts anew. And I can be reached on my cell. I'll go ahead and give you my cell, 727-214-4930. I've been practicing criminal defense for over 23 years. I'm happy to give anyone that reaches out a free consultation, particularly with the issues that we've been discussing this morning and into the afternoon. And that's it. Thank you again for having me on to discuss these issues.
Okay, guys, don't forget, hurricane season is not over yet, so be safe. And we will see you guys next Sunday on The Rotation.
Bye.